File items 52 and 53, pass and retain. We are moving to file item number 54. That's SB 519. Clerk will read.
Senate Bill 519 by Senator Hancock and others, enact relating to parole.
Mr. Jones Sawyer, would you like to take up this item?
Mr. Speaker, SB 519 is a technical cleanup bill for SB 261 by Senator Hancock, which was approved earlier this month on this floor on a bipartisan vote. The administration has had some concerns with implementation deadlines in that bill. SB 519 addresses the administration's concerns by adding an additional 6 months to that bill's deadlines. I respectfully ask for your aye vote.
Thank you, Mr. Jones Sawyer. Seeing no discussion on the item, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. The clerk will close the roll, tally the vote. Ayes 54, noes 13. Measure passes. We are going to pass temporarily on file item 55. Moving to file item number 56. That's SB 635. The clerk will read.
Senate Bill 635 by Senator Nielsen and others, enact relating to erroneously convicted and imprisoned persons.
Mr. Bonta, you may open.
Thank you, Mr. Speaker and members. SB 635 modestly increases the amount an exonerated person receives in restitution compensation, which has not been adjusted for inflation in nearly 2 decades. Specifically, the bill raises potential compensation for wrongful incarceration after a person is found factually innocent to not more than $140 per day spent incarcerated. This is an increase from the $100 per day spent in incarceration that is an existing law. Additionally, the bill allows time served in jail prior to conviction to be eligible for compensation. Members, this bill attempts to address perhaps the greatest nightmare that can occur in the American justice system, the wrongful conviction and incarceration of an innocent person. I respectfully ask for your aye vote.
Thank you, Mr. Bonta. Seeing no discussion on the item, the clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the vote. Ayes 72, no 0. Measure passes. File items 57 through 59 pass and retain. We are moving to file item number 60. That's SB 800. The clerk will read.
Senate Bill 800 by the Committee on Business, Professions, and Economic Development and Act relating to healing arts.
Mr. Gordon.
Thank you, Mr. Speaker. SB 800 is the Senate Committee on Business, Professions, and Economic Development's annual health omnibus bill. This bill makes several minor, non-substantive, and technical changes to the Business and Professions Code. These are consensus items that will better enable the boards to carry out their regulatory duties. There is no known opposition. The bill has passed Policy and Fiscal Committee in both houses on consent, and I respectfully ask for your aye vote.
Thank you, Mr. Gordon. Seeing no discussion on this item, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the vote. Ayes 69, no 0. Measure passes. File items 61 through 63, pass and retain. We are moving to file item number 64. That's Senate Bill 178. The clerk will read.
Senate Bill 178 by Senator Leno and others, and act relating to privacy.
Mr. Obernolte, you may open.
Thank you, Mr. Speaker. Colleagues, over 200 years ago, one of the chief catalysts for the American Revolution was the issuance of writs of assistance by the British government. Writs of assistance were documents that allowed any government official to search any person at any time and any place for anything and for any reason without even suspecting that person of a crime. The American colonists hated the writs of assistance. They hated them so much they were called the hated writs. And those writs were one of the key things that led the colonists to rebel against Britain and led to the formation of our country. When our country was formed and our Constitution was created, Our founding fathers enshrined the hatreds for those kinds of searches in the Fourth Amendment to our Constitution. Our Fourth Amendment prohibits unreasonable searches and says that before a person's home or papers or effects are searched, the government must prove probable cause and specify exactly what the object of the search is. Mr. Speaker, permission to use a prop.
Without objection.
Colleagues, we live in a remarkable technological age. The device that I hold in my hand is capable of storing and recording not only every letter that I've ever written, but every person that I've ever met, every photograph that I've ever taken, every book I've ever read, and the GPS coordinates of every place that I've ever visited. It's very clear that the information stored on this device falls under what the Fourth Amendment calls papers and effects. But unfortunately, our laws here in the state of California have not kept up with technology. In fact, privacy law in the state of California is still governed under the Electronic Communication and Privacy Act passed by Congress way back in 1986 when this device was just a dream. We need to catch up our laws to the state of our current technology, as other states have done. In recent years, 16 other states have updated their state codes to comply with this. And that's why I'm very proud to introduce, on behalf of Senator Leno, the California Electronic Privacy and Communications Act, SB 178. SB 178 would clarify that the protections of the Fourth Amendment to the Constitution also apply to electronic devices and electronic communication. Now, I think it's very important when we're talking about privacy legislation that any legislation that we pass strike an appropriate balance between the privacy needs of our citizenry on the one hand, and on the other hand, the needs of our law enforcement community to be able to conduct these searches to appropriately investigate and prosecute crimes. Colleague Senator Leno has worked tirelessly over the last few months to address the concerns of law enforcement organizations throughout the state, and I'm confident that this legislation achieves that balance. Colleagues, it makes no sense that the email in your inbox should enjoy different protections than the mail in your mailbox. And that's why I respectfully urge an aye vote on SB 178.
Thank you, Mr. Obernolte. Mr. Gatto, you are recognized.
Thank you, Mr. Speaker. About 5 years ago on this floor, the same author of this bill, Senator Leno, came up with a proposal that was a little more narrow. It had to do with our cell phones and police demanding them at a traffic stop. And we saw something unique. We saw an 80-0 vote in the Assembly. I saw my colleague, I guess I can use his name, he's no longer with us, Tim Donnelly, stand up and speak for this bill on the perspective of the conservative faction. And I saw many people, civil libertarians, get up and speak for it on the liberal faction. What everybody agreed on is that we need more protections in California law. That bill was vetoed, though, and these practices continued. And then just last year, in a 9-0 opinion written by the most conservative justice, the United States Supreme Court agreed with our colleague, Mr. Leno. Well, this bill, we have the opportunity to extend those protections to electronic communications so that they can't just look at your call data, but to also protect things like your email as well. My colleague from the high desert said it very well. These type of data demand the same protections as mail. They should be protected by the Fourth Amendment. Until then, I think it's the duty of state legislatures to step in and make sure that we protect our citizens. We are all keenly aware of how much of our everyday lives occurs on these devices and how antiquated current California privacy laws are. This bill not only protects our constitutional rights of privacy, but the language has been carefully crafted with the input of all of the state's law enforcement groups to make sure that it gives police the essential tools to continue to protect our public safety. We can't let this debate be hijacked by baseless claims. Protecting the rights of Californians and providing clear rules for companies is far, far too important. Just ask your constituents, they'll tell you. To be clear, this language has been carefully crafted to ensure that it does nothing to hinder investigations. All undercover investigations, including peer-to-peer networks, will continue to be accessible without a warrant. Law enforcement can seek a notice of delay to make sure that if there's somebody where the data will disappear, that they can delay the service of the warrant if they need to. Notice is not provided until the warrant is issued, and it can be delayed for up to 90 days if destruction of evidence might occur. This is 3 times longer than what's allowed for wiretap notice. SB 178 will not undermine law enforcement's ability to access any databases to protect children or the most vulnerable. SB 178 has no effect on a company's rights or obligations to disclose information about egregious crimes. Federal law, colleagues, mandates those disclosures, and of course, this bill cannot affect federal law. The California Sheriff's Association said it well when they thanked the author for addressing their concerns and removed opposition from the bill. They said, and this is the California Sheriff's Association, that the correct balance is struck between the needs of law enforcement and the needs and privacy rights of Californians. Colleagues, I am proud to stand up for this bill today, a bill that preserves citizens' rights, which were so important to our founding fathers and should be important to you as well.
Thank you, Mr. Gatto. Mr. Gordon, you are recognized from your desk.
Thank you, Mr. Speaker. As a co-author of SB 178, I rise in strong support of this legislation. Outdated privacy is not just bad for Californians. It's bad for business, and it's bad for the California economy. California cannot continue to have outdated privacy laws. These laws have created a maze of different rules and procedures at every high-tech company in our state. That's why this bill has wide support from California's leading technology companies, many of which are based in and around my district, supported by Apple, Facebook, Twitter, Google, Microsoft, and LinkedIn. This bill will create for them and for all of us consistent and easy rules to understand for all. This bill is good for California's tech companies, it's good for business, it's good for law enforcement, and it's good for the people of California. I ask for your aye vote.
Thank you, Ms. Gordon. Mr. Quirk, you are recognized.
Members and Speaker, I rise in strong support of SB 178. Every important document I have right now is out there in the cloud. That needs to be protected, just like my documents in my file cabinet that I no longer have. I ask for your aye vote.
Mr. Wagner, you are recognized.
Thank you, Mr. Speaker. Briefly, we've seen courts too often add to or subtract from what is in the Constitution. They do so illegitimately. They do so on the right. They do so on the left. And what we have here is the right way to do this. This is the legislature saying the Fourth Amendment means something. It was written back in the 18th century, but the idea of papers and personal effects, whether they are written down and stored, in a closet or under your bed, or whether they are written down electronically and stored on your phone, that's the same thing. We're not adding to the Constitution. We're not subtracting from the Constitution. Senator Leno has been a champion on this issue. I was proud to floor jockey a couple of his bills a few sessions ago on precisely this issue. We are doing the right thing when the legislature grapples with these issues and saying we are going to protect the privacy of our citizens. This is a great bill. I urge an aye vote.
Thank you, Mr. Wagner. Mr. Cooper, you are recognized.
Thank you, Mr. Speaker and members. I heard a lot of authors talk, or folks that get up and talk about this bill, and one of the things when our Constitution was written, it never talked about child pornography, and that's a serious concern of mine. I support an individual's right to privacy. However, as a former commander of the Internet Crimes Against Children's Task Force, I can tell you SB 178 will limit law enforcement's effectiveness in identifying, investigating, and prosecuting sexual predators. Currently, there are 5 ICACs in the state of California: Sacramento, San Jose, Fresno, LA, and San Diego, and 61 nationwide. SB 178 lumps all crimes committed using electronic communication over an electronic device in the same investigative categories. This means complex child pornography networks will be under the same investigatory restrictions as less serious crimes, such as selling a stolen bike on Craigslist. SB 178 mandates a suppression of all evidence gained from a legal search warrant if the process and procedures of SB 178 are violated in any manner. This is a technical loophole that will benefit a sexual predator and put children at risk. And for my colleagues that are attorneys in here, what other law is there that restricts the evidence obtained in a search warrant unless it's obtained illegally? Just a loophole right away out of the gate. It is routine that investigations involving child pornography, sexual exploitation of children, luring, and human trafficking rings lead to dozens of search warrants to disrupt and dismantle a criminal network that targets the sexual exploitation of children. SB 178 places impractical and unrealistic restrictions as it relates to gathering evidence against these networks. SB 178 fails to clearly identify what constitutes an emergency. This is too ambiguous for crimes involving the distribution of child pornography, exploitation, luring, and human trafficking. These crimes against children routinely lead to serious psychological issues, but do not often result in serious physical injuries or death, as the bill requires. SB 178 needs to be clear. So let it be clear. You can be molested and sexually assaulted, and you're probably not going to die for it. So under SB 178, that is not an emergency. SB 178 establishes the same search warrant requirements to recover stored data evidence with live content evidence by raising the search and seizure requirements to a level of federal and state wiretap laws. SB 178 is a one-size-fits-all bill that weakens the ability of law enforcement to effectively investigate child exploitation networks and secure evidence. Over 80% of the convicted internet exploitation suspects have committed sexual assault on a child by the time of their arrest for an internet crime against children. In California, there have been over 60,000 personal computers and devices used to distribute images and videos of children and infants being sexually assaulted. It is estimated that in California, there are currently over 30,000 children waiting to be discovered and rescued from sexual exploitation and assault. Many won't be saved if SB 178 becomes law. Permission to use a prop, Mr. Speaker?
Without objection.
Here's a book downloaded off the internet, How to Practice Child Love. Child Love Explained by Professionals. This is an education and step-by-step guide for adults to engage in and practice sexual relations with underage children. The purpose of this guide is to teach adults how to safely and harmlessly practice sex with children without hurting the child by using advanced and well-researched psychological and pediology. And just one more sentence, Mr. Speaker. So you will first need to make yourself available as a babysitter. This might be a little tricky since you will need to be careful and a little bold at the same time. Right now in Sacramento, a couple of years ago, we had about 300 cyber tips, which is for child pornography, a month. Now we're up to 600 a month. And currently there are about 500 to 600 IP addresses just in the Sacramento area that are trading child pornography back and forth. I've seen these videos. I worked the task force. I commanded it. You're talking people, infants, digital penetration. Those are harsh words. Kids, 5 and 6 years old, people having sex with them. Bestiality, bondage, kids screaming. These are videos investigators look at every day.
30 seconds, Mr. Cooper.
And that's really the big issue with this. You can't think about that. It's not a one-size-fits-all. Let's put kids' rights first, not internet privacy. Internet privacy is not about child pornography. And most of us don't know this, but to be there 3 years, it's insane that adults do that. The internet is a great thing, but it's a bad thing. 20 years ago, 30 years ago, if you were a pornographer, child pedophile, there's nothing to find it on. The internet is ripe with millions and millions of pictures. Let's stand up and protect our children and make it safe for them. That's really what it's about, our kids, and not about some internet company.
Thank you, Mr. Cooper. Mr. David Chu, you are recognized from your desk.
Thank you, Mr. Speaker. Colleagues, I first of all want to say I appreciate this discussion that we've been having. These are difficult issues that we must grapple with, and I think everyone in this room understands that at the end of the day, as has been already stated, when the Fourth Amendment protects our mailboxes, protects our cars, protects our houses, it would be illogical for us not to have protection with regards to our emails, with regards to our texts, with regards to our cell phones. Now, all that being said, I have grappled with the concerns that have been raised by our colleague from Elk Grove. As a former prosecutor, this is something that I take seriously, and I don't think there is a single member of this body who would want to vote for a bill that somehow would permit those who are engaged in crimes around child pornography or crimes against children to be permitted. That being said, I have read this bill carefully. I also appreciate the amendments that were made by the author in the last couple of days. And let me just quote, first of all, there is language specifically in this bill that states that law enforcement is allowed to retain any information it reasonably believes related to child pornography, and the information retained as part of a multi-agency database used in the investigation of child pornography and related crimes. The author of this bill has directly addressed these issues that have been raised by law enforcement within this past week. This bill also explicitly states that companies can disclose information that is either required by law or not otherwise prohibited by law. And it is clear that federal law states and mandates that companies must disclose criminal material involving minors to relevant authorities, as well as it allows for voluntary disclosure of information in a variety of appropriate situations, including that involving missing children. This bill, the intent of this bill and the language of this bill will have no impact at all on a company's obligations to disclose information about crimes against children. Colleagues, I know we are all weighing this bill carefully, but I can assure you the reason over the last few days the California Police Chiefs Association, the California District Attorneys Association, the California State Sheriffs Association, as well as the California Statewide Law Enforcement Association, the reason they are no longer opposing this bill is because amendments have been made to address it. And if I could just state some of their letters to us from the police chiefs. SB 178 strengthens community relationships and increases transparency without impeding on law enforcement's ability to serve the needs of their community. From the DAs, I'm pleased to inform you that they're removing their opposition, appreciating the willingness of the author to work and address the concerns. From the sheriffs again state that the correct balance has been struck between the need for law enforcement to obtain information regarding criminal activities. Again, I understand there are a lot of concerns that have been raised about this bill, but I do think that the author has addressed them. I think he has addressed them explicitly, and with that, I am planning to support it. And again, I appreciate everyone's concerns and questions that have been raised about this.
Thank you, Mr. Chu. Ms. Olson, you are recognized.
Thank you, Mr. Speaker and members. For many of the reasons stated by the previous speaker, I too rise in support of SB 178. It is time, as the floor manager spoke to, it is time to update our antiquated laws to keep up with advancements in technology. And the fact is, when you really drill down to it, there is nothing different between records that are held in this phone and mail that I receive in my mailbox. Colleagues, I'm a mother of 3 young kids. I've worked with abused children over a number of years, and so I appreciate the comments made by our colleague from Elk Grove, and I appreciate the fact that every single one of us take those comments very seriously. And because of that, I looked very closely into the detailed language of this bill. I spoke with law enforcement leaders to make sure that nothing in this bill would prevent them from going after child pornographers and others that would commit heinous crimes against children without the same ability and force that they have today. And they have assured me that they can still do so. It is possible to protect our kids and to protect our basic rights to privacy. This bill simply says that you shouldn't be able to search our phones without a search warrant. If I'm pulled over on the side of the road, there is no reason I should have to turn this over to anybody who pulls me over without them having a search warrant. And that is all we're talking about in this very basic bill. Because of amendments that have been taken by the author, law enforcement has dropped their opposition. The district attorneys, the police chiefs, the sheriffs, and the list goes on. There are exceptions in the bill for undercover investigations. There are exceptions in the bill for cases when there is danger to life or danger to physical safety, and very few groups are still opposed. In fact, there are renowned child protection experts, some CEOs of child protection nonprofit organizations, who have stated emphatically that the continued opposition is unfounded. They have looked at this bill from top to bottom, inside and out, and they are absolutely confident. And again, these are CEOs whose sole purpose and mission of their organizations is to keep kids safe from the internet and other ways. Recent amendments ensure that we can protect children from child pornography and other crimes, and at the same time protect all of us and all Californians from unlawful search and seizure. We can protect kids and protect privacy at the same time. I urge and I vote.
Thank you, Ms. Olson. Mr. Williams, you are recognized.
I want to rise in uneasiness about this bill. I want to agree with my colleague from Elk Grove that the definition of harm should have specifically called out issues like child molestation, human trafficking, and I am uneasy to vote aye until that is addressed and addressed more explicitly than it is in the bill. So for now, I will not be supporting this bill.
All debate having ceased on the measure, Mr. Obernolte, you may close.
Thank you, Mr. Speaker, and I want to thank all of my colleagues for your very thoughtful remarks. I'd like to specifically address the comments made by my colleague from Elk Grove, very poignant comments. And I want to let you know that I struggle with this issue as well. I have many responsibilities, as you do. I'm an assemblyman, I'm a business owner, I'm a husband, but I'm also a father. And the last thing I would ever do would be to support a piece of legislation that put my children at risk. But I'm convinced that this legislation strikes an appropriate balance between the rights of our citizens to privacy on the one hand and supporting the efforts of law enforcement agencies to prosecute crimes against children on the other hand. And you don't have to take my word for it. I'd like to read from you, with your permission, Mr. Speaker.
Without objection.
This is a letter we received from Larry Magid, the CEO of ConnectSafely.org, founder of SafeKids.org, and author of Child Safety on the Internet Highway, which is a safety pamphlet put out by the National Center for Missing and Exploited Children. He says that I believe SB 178 has the necessary provisions to assure that law enforcement can vigorously protect children and access the necessary information to investigate crime while at the same time extending basic constitutional protections to our digital information. I'd like to close with a small excerpt from the court decision that was referenced by my colleague from Glendale. This is a court decision by the U.S. Supreme Court from last year. It was United States versus Riley. And the court said, the fact that technology now allows an individual to carry such information with him in his hand does not make the information any less worthy of the protection for which our founding fathers fought. Colleagues, this bill is worthy of your support. I respectfully request your aye vote.
Thank you, Mr. Obernolte. With that, the clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. This requires 54 votes, members. All members vote who desire to vote. 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 Mr. Obernolte.
Speaker, I move the call.
Mr. Obernolte moves the call. Members, we are at file item number 65. Senate Bill 238. Clerk will read.
Senate Bill 238 by Senator Mitchell and others, enacting the foster care.
Mr. Chu, you may open.
Thank you, Mr. Speaker and colleagues. Today, we're going to consider a package that brings much-needed oversight and revised procedures for the use of psychotropic drugs in the foster care system. As has been recently documented, nearly 1 in 4 children in foster care and 56% of children in group homes have received and have been prescribed psychotropic drugs, in many cases multiple prescriptions, without adequate oversight. This over-medication of our foster care youth has led to a multitude of adverse long-term health impacts, including crippling sedation, cardiovascular disease, diabetes, morbid obesity, memory loss, and irreversible tremors. Today, we're going to consider 3 bills of this legislative package that have received unanimous bipartisan support through both houses. The 4th bill has been made into a 2-year bill to be considered early next year. This bill, SB 238, would provide child welfare social workers and other partner agencies with the data, training, and tools to provide appropriate oversight. These are social workers that have to rely on medical and behavioral experts who often don't have the data regarding appropriate treatment. This bill requires our state departments of social service and healthcare services to develop monthly data reports matching prescription and claims data with child welfare services that will be shared with counties, the courts, attorneys, and county-appointed advocates. It requires the development of an alert system triggered when potentially dangerous interactions could occur between prescribed medications. It updates court forms to provide opportunities for key stakeholders, mandates trainings for doctors, social workers, foster care kids, caregivers, attorneys, and advocates. And with that, I respectfully ask for an aye vote.
Thank you, Mr. Chu. Seeing no discussion on the item, the clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the vote. Ayes 58, no 0. Measure passes. We are at file item number 66. That's Senate Bill 319. The clerk will read.
Senate Bill 319 by Senator Bell and others, enacting the Child Welfare Services.
Mr. Chu, you may again open.
Thank you, Mr. Speaker. Colleagues, this is the second of three bills that we're considering today to tackle the overprescription of psychotropic drugs in the foster care system. This bill would strengthen the role of public health nurses to oversee the monitoring of foster youth psychotropic drug use by giving nurses the explicit authority to request and review a foster use medical information. Under current law, a public health nurse does not have this authority. Again, this bill has had unanimous bipartisan support through the process, and I respectfully ask for your aye vote.
Thank you, Mr. Chu. Seeing no discussion on the item, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the vote. Ayes 58, no 0. Measure passes. We're at file item number 67. That's SB 334. The clerk will read.
Senate Bill 334 by Senator Leva and others, enacting the public health.
Mr. Rendon, you may open.
Thank you, Mr. Speaker and members. SB 334 is about making sure that children throughout California drink clean and safe water in their schools. Unfortunately, harmful chemicals such as lead may be present in water provided at some California schools due to inadequate upgrades to aging school facilities. This is an issue that should not be ignored. SB 334 prohibits schools from providing drinking water that does not meet the U.S. EPA drinking water standards for lead or other contaminants. Further, this bill requires school districts to take measures each school day to provide free, clean, and safe drinking water on campus. Children can develop anemia, stomach problems, and even liver or kidney damage, and even minimal exposure can make it difficult for students to learn and excel in school. SB 334 recommits our state and schools to providing safe drinking water. Since there is currently no statutory requirement for the water coming out of the drinking fountains at our children's schools to be safe for consumption, this bill has received strong bipartisan support in both schools. I respectfully ask for your aye vote.
Thank you, Mr. Rendon. Seeing no discussion on the item, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. The clerk will close the roll, tally the vote. Ayes 58, no 0. Measure passes. We're at file item number 68. That's SB 387. The clerk will read.
Senate Bill 387 by Senator Jackson, enacting relating to the State Bar.
We're going to pass temporarily on that item. Per Mr. Stone's request, we're going to pass and retain. Pass and retain on file item number 68. That moves us to file item number 69, Senate Bill 484. Clerk will read.
Senate Bill 484 by Senator Bell and others, enacting relating to juveniles.
Mr. Chu.
Thank you, Mr. Speaker. Colleagues, this is the third bill that we're considering today to address the overprescription of psychotropic drugs in the foster care system, of which I'm a principal co-author. According to state data on the use of these medications by foster youth, more than half of children in group homes are medicated with one or more psychotropic medications. 65% of children living in group homes are prescribed these medications. 61% have been given an antidepressant. Hundreds of children living in group homes have been given multiple medications over the long term. This bill, SB 484, would institute oversight measures in group homes using the Department of Health Care Services' existing data collection model to monitor and analyze psychotropic drug use in these group homes. The bill utilizes the existing Community Care Licensing Division to inspect if a corrective action plan is necessary for a variety of homes where they're deemed unnecessarily overprescribing of psychotropic drugs. The bill has had unanimous bipartisan support through the process, and with that, I respectfully ask for your aye vote.
Thank you, Mr. Chu. Seeing no discussion on the item, the clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the vote. Ayes 58, no 0. Measure passes. Members, without objection, I am going to move to file item number 86 by Mr. Chu will be the jockey.